my husband passed on 2004 early March. I've come to this court so many times, it's over now 20 years, but there's no justice being done. In spite of the fact that I've brought all the documents supporting the ownership of my husband. This succession court in BUNGOMA High Court has never taken any trouble to prove the ownerships of my husband. Instead, they have mixed with the ownership of my mother-in-law. And that has led me to have no confidence in this succession court in BUNGOMA High Court as I'm standing here. But what surprises me, I have every document. I have the plans for the shops. We have been paying rates to Municipal Council of Webuye. We were listed, we have green card, we have everything. But this court has failed to prove who is the true ownership of those plots. Instead, they went and even nullified my confirmation date of grant, which was officially obtained. And after nullifying that, they just left it there. So I felt it was not fair, surely, for the court, instead of taking trouble to find the true owner, they just go by the majority of numbers. And since my family is just very few members there, they don't consider us. Instead, the judge asked me to be one of the administrators. But I said, how can I be administrator to my father-in-law's property? I want to be administrator on my late husband's property. That question was never answered.
Before this court, for that objection, because I need to give directions on 25th of September, because the term is drawing to an end. This lady has come to court severally. I even now appointed her as an administrator in the estate after a lot of wrangles in this matter, and gave them time to file an application to confirm the grant. One, the application to be filed for confirmation of the grant. That is still pending because I have a valid, there's a ruling here that I gave on the 14th of June, appointing the same Selina as an administrator on behalf of her late husband's unit. Okay? And I gave the parties directions that any one of them could file an application to confirm grant. She has the liberty to do that. He has the liberty to do that. He has explained that he has received instructions this morning, for which I find valid. So that the parties have sufficient time to file that application. But I'm also going to give Selina the leeway to file her application, and a proper application, not a preliminary objection, a proper application for this court to disqualify itself. I cannot hang on to a matter when a party feels that she's getting injustice.